Question 8. Which section of CRPC provides that in case the aggregate of consecutive sentences passed against an accused by a magistrate shall exceed 14 years? In no case. Yes. The concerned provision is section 31. It deals with conviction of an accused of several offences. In one trial, if an accused is convicted of several offences and if the sentences are to run consecutively, then even a magistrate can give punishment totaling to maximum of 14 years. This is what the second part of section 31 says. The offender shall not be sentenced to imprisonment for more than 14 years. And the aggregate punishment shall not exceed twice the punishment which that court is competent to inflict for single offence. Now, if you take the example of the court of a judicial magistrate, first class, his power in a single case for maximum punishment is 3 years. In case of multiple offences, the aggregate punishment can be up to twice this limit, that is up to 6 years. So in case of judicial magistrate first class, the maximum that can be given by that magistrate, even in case of multiple offences, it is 6 years. But in case of chief judicial magistrate, the multiple offence punishment can go up to 14 years because his power is up to 7 years, and if you double that, it comes to 14 years. So we would say that under section 31, a chief judicial magistrate is empowered to award a total punishment of imprisonment of up to 14 years in case an accused is convicted of multiple offences in a single trial. This is important. Multiple offences, conviction for multiple offences in a single trial. For one particular offence, the chief judicial magistrate can award a sentence of only up to 7 years. But in case of multiple offences, the aggregate punishment that can be awarded by him can go up to 14 years. This is section 31. This again is a very important section. The number should be remembered. Question 9. Inherent powers of the High Court are contained in which section of CRPC? Now, firstly, the question itself needs to be remolded, because if the powers are inherent, then they cannot be contained in any section of CRPC. If a provision of CRPC gives these powers, then they are not inherent powers, then they are given by the CRPC. The very expression inherent powers of the High Court indicates that these powers are not given by any provision of law, these are inherent. With that observation, we now move on to the relevant provision of CRPC which deals with, in some way or the other, it deals with the inherent powers of the High Court. The concerned section is 482. This section only says that any provision of CRPC shall not limit or affect the inherent powers of the High Court. So those powers are inherent, they are not given by anybody. 482 only emphasizes that these inherent powers cannot be limited or affected by any provision of CRPC. Of course, in the later part of this provision, we find that these inherent powers of the High Court must relate to prevention of abuse of the process of court. They must relate to securing the ends of justice, and these inherent powers should relate to giving effect to any order under CRPC. So in a way, there is some mention of the kind of powers which are termed as inherent, and on the other side, the same section says that CRPC shall not limit or affect the inherent powers of the High Court. In any case, the answer is section 482. That is the only section which makes a mention of the inherent powers of the High Court. Question 10. Payment of compensation to a victim is provided under which section of CrPC? The answer is 357A. This section contains a victim compensation scheme where every state government is required to prepare a scheme for providing funds. Funds are to be provided by the state government, and these funds are to be used for giving compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Not to every victim. There are different provisions regarding the authority which will decide the quantum of compensation. This provision is only telling us as to who will provide the funds for such compensation. Question 11. Which section of CrPC empowers a court to summon a material witness or examine a person present in court? The answer is straightforward. Section 311. This section empowers any court to summon any person as a witness at any stage of any inquiry, any trial, any other proceeding. It also empowers the court to examine any person who is present in court, though he was not summoned as a witness. Therefore, any person who is present in a criminal court in whatever capacity can be examined by the court at any stage. This power is provided to every criminal court under section 311. Question 12. Which section of the Code of Criminal Procedure allows a person making an arrest to seize offensive weapons? The answer is section 52. This section provides that the officer or other person making an arrest, we are aware that under chapter 5, not only a police officer but other persons can also make arrests. A private person is empowered to make an arrest under section 43. A magistrate is empowered to make an arrest under section 44. And police officer, of course, can make an arrest under 41 and 42. So the police officer or other person, whoever he is, whether a private person or a magistrate, making an arrest may take from the person arrested any offensive weapons which he has about his person. So whatever offensive weapons are being carried by the person on his person may be seized by the person who is arresting him. Offensive weapons are those weapons with which an offense can be committed. Section 52.